Tonight, a clock struck 6:15 p.m., Parchman, Mississippi. A door opened. A life ended. Another life, long ago, could never return. And a question, sharp, stubborn, impossible, remains. When the state declares justice complete, who carries what's left of the truth? Picture two rooms. In one, a mother holds a photograph of her 20-year-old daughter, Kristy Ray, bright eyes, unfinished plans, a chair at the table that never stopped being hers. In the other, a steel gurney, bright lights, witnesses behind glass, a man named Charles Ray Crawford, who has run out of appeals, out of minutes, out of breath. Between those rooms is a long, torn road called justice, paved with verdicts, petitions, and the weight that grief and guilt both refuse to drop. This isn't simple. It never was. The crime was horrific. The sorrow is permanent. And yet, even in the final hours, a constitutional fight flared about who owns a defendant's voice when the stakes are life and death. A Supreme Court dissent warned that Crawford's lawyers once told the jury he was guilty against his wishes, raising a question about whether the rules that protect a person's voice came too late to protect his. On a January night in 1993, a young college student vanished from her family home in Tipper County. Her name was Kristy Ray. Her family faced an empty doorway, a ransom note, and the sound a house makes when it's holding its breath. When investigators followed the trail, they found Charles Ray Crawford. The facts that jurors heard were grim: kidnapping, sexual assault, murder. The jury returned a verdict. A Mississippi judge imposed death, and time, thick and grinding, began. Years became decades. Appeals rose and fell like seasons. Direct appeals, post-conviction petitions, federal habeas review. Some arguments were rejected. Others were never heard on the merits because of rules about when and how you must raise them. Meanwhile, families on both sides lived with calendars that circled parole hearings, court dates, execution warrants, the legal system's slow metronome tapping through their lives. Mississippi set an execution date, then stayed its hand, then set another. Lawyers filed, reporters called, advocates gathered. Opponents of the death penalty raised familiar alarms. Supporters spoke of accountability, of a promise made to survivors that one day the state would finish what the jury began. In 2025, the state carried out its second execution of the year. At 6:15 p.m., officials pronounced Charles Ray Crawford dead by lethal injection at the Mississippi State Penitentiary at Parchman. But in the hours before the drugs flowed, another current ran through the case, a legal riptide that pulled at the foundation of the trial itself. The last petition focused on voice. Who decides the goal of a defense, lawyer or client, when life is at stake? In 2018, the US Supreme Court held in McCoy versus Louisiana that a lawyer cannot concede guilt if the defendant says no. In Crawford's case, a dissent argued that his counsel did concede guilt despite his protests, and that, had the case come at a different time, he might have won a new trial on that ground. The majority denied relief. The dissent said the court should have paused the execution to answer whether McCoy applies retroactively. The door did not open. The clock did not stop. So what do we do with a story like this? One that contains an irrefutable loss and an unanswerable question. We start by saying her name, Kristy Ray. A person, not a headline. A daughter, not a legal citation. Every time policy debates grow loud, we must keep faith with the family whose every sunrise has been colored by absence. Justice is not abstract to them. It's the hard edge they've held to so they don't fall apart. And we say his name too, Charles Ray Crawford, not to soften what he did, but to face what we did in response. Because a system defined by the power to end a life must be defined by relentless care, by procedures that are clear, rights that are honored, and a public that understands what it means to act in its name. When a justice of the Supreme Court warns that a man may have been executed without a full hearing on whether his own lawyers overrode his will, we owe it to ourselves to listen, not because the crime was small, but because state power is vast. This isn't about choosing between compassion for a victim and scrutiny of the state. We can do both. We must do both. We can honor Kristy Ray's life, respect her family's suffering, and still insist that every constitutional safeguard be tested to its last mile. That retroactivity rules not become a trapdoor beneath someone's feet, and that timelines never eclipse truth. The death penalty, if used at all, demands a standard beyond doubt and beyond convenience. It asks us to be surgeons with the law, not carpenters with a hammer. Look wider. Mississippi's execution was part of a year when executions rose across the country. Some see this as resolve. Others see an urgent warning that as the machinery speeds up, the margin for error narrows. In this case, the state completed what a jury set in motion long ago, yet the echo left behind isn't triumph. It's a hum of unfinished argument about rights and remedy, about how late is too late to correct a trial's course. And so we come back to the two rooms, the chair that will always be hers, the gurney that cannot be used twice. Neither room can give us back what was taken, but they can ask us who we want to be next time we face a case that mixes horror with doubt, grief with law, punishment with principle. Say her name, Kristy Ray. Hold space for love that didn't get to finish. Say his name, Charles Ray Crawford. Hold the state to standards that cannot bend. If we insist that every voice in a capital case is heard, even the defendant's when it contradicts his lawyers, then whatever verdict we render will not only answer the past, it will protect the future. Justice is not a single moment at 6:15 p.m. Justice is the sum of everything we do before we dare to say the word.